Hello friends, welcome to my channel MJS Knowledge Hub. I hope you're preparing well for examinations and we are doing the revision of ISCA CA final old syllabus paper number 6, right? And we have successfully completed chapter 2, 5, 3, 4. Now we are going to enter into chapter number 7. Chapter number 7 is all about the information technology regulatory issues. Okay, so here what are we going to study? Why we are taking this lesson now is that the reason is very I think I request you to once see the video study plan of ISCA so that you can understand why we are taking these steps sequentially. In chapter 2 we have seen what are the different type of information systems. In chapter 5 we have seen how to build a system. In chapter 3 we have seen how to protect the system, and chapter 4 we have seen how to have the business contingency plans, like for coping up with any disruptions by having business continuity planning and program and disaster recovery program. So we have seen these things. Now in chapter number 7 we are going to see what are the regulatory issues which we must abide by for getting the good information technology aspect in our system. So every action what we do here, we do in the society or in the organization is backed up by some requirement of some law and regulation, right? Companies, example, company has to follow income tax act and the companies act. Similarly, when you are having information technology in the organization, you must follow the few principles as required by the law. So what law we are going to discuss here? We are going to see Information Technology Act 2000. Then what are the important objectives of that act? Then we are also going to see certain definitions like authentication of electronic record, what is meant by hash function, then how can we say electronic signature is considered reliable or not, then what is meant by retention of electronic records, and then we are going to see the requirement of the information system audit for by various authorities like IRDA, Insurance Regulated Development Authority, RBI, Reserve Bank of India, and SEBI, Securities Exchange Board of India. What are the requirements by them? Then we are also going to see what is the SEBI auditor selection norms, which is one of the quite important questions. And then we are going to see what is meant by cyber forensic and cyber audit. Also, we are going to see National Cyber Security Policy 2013. What does the policy state? And then we will be moving to ISO 27001 standard to know about it, and then what are the four phases of information system management cycle that we are going to see. The plan, do, check and act phase, the cycle we are going to study, and then we are also going to see what is meant by ISO 27001, what are the benefits of what is going to do, and also we are going to finish the chapter by understanding and knowing ITIL, means information IT infrastructure library. So yeah, it is ITIL, information technology infrastructure library. So you will be seeing all these topics in this chapter, and finally we'll be concluding the chapter by knowing some of the penalties. So which section imposes what penalty, up to what extent, there is some basic rough idea we need to keep. So this all will be covering in this video. So without much delay, let's get started. So friends, nowadays we do everything which is linked with IT, right? If we want to buy something, we'll go and check the Amazon, or we want to know how to do something, we'll check on the Google, or if we want to understand a particular topic or need some explanation, we go to the YouTube. So everything nowadays is mostly in the digitalized mode. Even the small grocery shopping to the ultimate big shopping, including event management for any function, is done online, right? So this with the major developments being taken in India, being a developing country, information technology plays a vital role in creating even employment opportunities. Therefore, the government recognizes this aspect scenario of having a law required for managing the transactions and providing the effective safeguards to the people who are doing the transaction. It has introduced Information Technology Act 2000, because without an act or proper you can say that you won't get the required measures by implementing the act. So what is the thing actually is that though we are using the information technology in many of the aspects, without proper act or without proper regulation, things can go into violation also, right? There will be, if your contract is not recognized as per the law, how can the seller or the purchaser go make any claim if there is a negative aspect happen, right? Therefore, Information Technology Act 2000 was passed in the May 2000, and again it has been revised in the Information Technology Amendment Act 2008. So here, what does the Information Technology Act says, that it aims to provide legal framework under which legal sanctity is accorded for electronic records or electronic transaction. So whatever happens with the help of the technology, with the help of electronic technology, help of IT. So this act will give the legal framework, legal backing up, so that any activity of that done in the in the electronic form is being protected. So this act states that unless otherwise agreed, an acceptance of a contract made by express electronic means of communication and the same shall have legal validity and enforceability. The act is amended in 2008. What does the act says that? It says that in the unless otherwise particularly said, if any transaction is happening electronically with and it is completed by using electronic means of communication, it will have same legal validity and enforceability as if it has been occurred in pen and paper. So that is what the act is trying to aim. Then let us see what are the major objectives of the Information Technology Act 2000. So the objectives of what is the main purpose that it has been brought into, or what is it that is trying to protect or trying to achieve. First thing, to grant legal recognition for the transactions carried out by means of electronic data interchange. Means any transactions are being carried out with the help of this information technology. It is being providing the legal recognition that this transaction is valid, and also other means of electronic communication commonly referred to as electronic commerce in place of paper based communication. Means any transactions happening with the help of information technology or happening with the help of electronic data interchange, or which is even called as electronic commerce or e-commerce, which is taking place in the without the use of pen and paper. This act is going to give legal recognition for those transactions. Then to give legal recognition to the digital signature of authentication of any information. Then to facilitate electronic filing of documents with the government department. Now you can see MCA 21, all the records required for the company, and even GST nowadays, and also the income tax, and everything is being online. So the paperwork is bit reduced. So this act will facilitate electronic filing of document with government department because it will give a legal sanction to it. Then to facilitate legal sanction to electronic fund transfer between bank and other financial institutions where money is being transferred without a proper backing up. How can you legalize saying the money is done properly? Therefore, it will give legal sanction to electronic fund transfer between bank and other financial institutions. Then to give legal recognition for giving books of accounts by bank in electronic form. So it is specifically providing the legal recognition for the books of the bank kept in electronic form. Then like you can check your passbook online, you can check your mini statement online. Then to amend the Indian Penal Code, Indian Evidence Act, and Bank of Book Evidence Act 1981, and the Reserve Bank of India Act, because these four acts require the hard copy of the paper as evidence. Therefore, amending the Indian Penal Code, Indian Evidence Act, Bank of Books Evidence Act, and Reserve Bank of India Act, it can provide legal sanction for the books of accounts or for the electronic fund transfer or for any transactional transaction of the bank done with help of information technology. Good. So chapter 3 of the Information Technology Act gives legal recognition to the electronic records and digital signature. Having this recognition is very important because without the legal backing, the signature won't be valid. The electronic records can't be used as an evidence. Okay. Then what is meant by electronic record? Authentication of electronic record. Authentication means you are providing validation of electronic record. So section 3 of the Information Technology Act 2000 deals with authentication of the electronic record. That is subject to the provisions of this section. Any subscriber may authenticate an electronic record by affixing the digital signature. If you want to authenticate, if you want to validate any electronic record, you can do that by having the digital signature. The authentication of electronic record shall be effected by the use of asymmetric crypto system and a hash function which envelop and transform the initial electronic record to other electronic record. How do you provide the security authentication or validation? You will do with the help of asymmetric crypto system and a hash function. These two will be enveloping and transform the initial record to another electronic record. If you transfer it to another electronic record, the sanctity can be retained and no one can change the data, right? Then any person with use of public key of subscriber can verify the electronic record. So who has a public key only can see and understand the electronic record, and the private key and public key are unique to subscriber and they constitute a function key pair. So this is about authentication of electronic record. Okay. Then let us try to understand what is meant by hash function and how the electronic signature or electronic authentication technique shall be considered reliable. What is hash function? Hash function is algorithm. Algorithm means mapping or translation of one sequence of bits into another. So it is a form of you can say form of a code which helps in translation of one sequence of the information or data into another sequence called as hash result, such that electronic record yields the same hash result every time the algorithm is executed. Whenever you use the algorithm always on this particular record, always it produces the same transaction. If something gets disturbed within the in the program, then the hash result we won't get the hash result and document can't be retrieved. Therefore, whenever you use this hash result, it will provide the same. Every time you use the algorithm, it will provide the same hash result with the same electronic record as input, making it computationally infeasible. Means computationally you cannot crack the code to extract the data unless until you use the same hash result with the algorithm. Therefore, where it is being used, it is used to derive or reconstruct original electronic record from the hash result produced by the algorithm. So the algorithm will produce the hash result helps in rebuilding the original electronic record. If any damage happens to the hash result, you cannot retrieve the original electronic record. Then the two electronic records can produce same hash result using algorithm. So the algorithm which has been developed by two electronic records, same will be developed by those two electronic records always when the algorithm is being always when the hash result is being used. Therefore, hash function means algorithm mapping or translation of one sequence of bits into another, generally smaller number known as hash result, such that the electronic record yields the same hash result every time the algorithm is executed, with the same electronic record making its input computation infeasible. Today, what is the purpose of hash function? To derive or reconstruct the original electronic record from the hash result produced by that algorithm, and the two electronic records can produce the same hash result using the algorithm. So this hash function, this you not very much about this definition. This will not be much asked. So just you remember that it is an algorithm which will be helping one sequence of bits to another called as hash result, and the electronic record is the same hash result every time when the algorithm is being executed. So the two electronic records when the algorithm is being executed result in the same hash result, so that the other person can't retrieve the data. Only by using the cut algorithm from the cut and the cut hash result you will get the original data. And once if and these two records will produce the same hash result using the algorithm. So this is meant by hash function. Now let us see how any electronic signature or electronic authentication technique can be considered reliable. So friends, we have just understood just now what is meant by hash function and what is meant by authentication of electronic records. So but the question comes, how can we say that this authentication thing which uses the signature is reliable or not? So how are the electronic signatures or electronic authentication technique decided to be considered to be reliable? Because you're signing or giving authentication or validation to any particular document electronically. So how can we say that the signature is reliable? First thing, you need to see that the signature creation data or the authentication data are within the context to which they are used and linked to signatory. Means the signature creation and or the authentication data which you are trying to authenticate are up to the context, means they are relevant to what they are being shown, and they are linked to the person who is signing it. Then the signature creation data or the authentication data where at the time of signing are under the control of signatory, means who is signing it must have control and grip over the data, and he must not lose it. Means it must not be taken in the control of someone else and signatory is just only signing it. It is not like that. If you want to designate the authentication is reliable, we need to see that the data is under the control of signatory. Then any alteration of electronic signature made after the fixing such signature can be detected. Means there are certain protocols which protocols, or we can say certain technological aspects which will show that the electronic signature has been disturbed after it has been fixed. That any alteration in information made after authentication by electronic record is detectable. Not only signature, if anyone tries to change the information after the signature has been kept, after authentication has been done, then there must be certain technological aspects in that which will be showing that the data has been altered after the signature has been done. So if these facilities are there, it fulfills other conditions as being prescribed. If these conditions are inbuilt in that signature thing, then we can say signature is reliable. What are those? Signature creation data or authentication data must be within the context for which they are being used and linked to the signatory or the authenticator and of no other person. The signature creation data or authentication data at the time of signing under the control of signatory, as the case may be, or under the control of the authenticator and no other person. Then any alteration to the electronic signature made after fixing the signature is detectable. Any alteration to the information made after its authentication by electronic signature is also detectable. And any other conditions, if there are there, it must be followed by the electronic signature or authentication technique. Then only we can say they are reliable. Okay. Then we are doing these things, and we are having now instead of having physical copy of the books, we are maintaining electronic records, and we are trying to provide evidence based upon electronic record, right? Then what is there any time limitation about storing of these records, or what we need to keep in mind when it comes to retention of electronic records? First thing, section number 7 deals with the retention of electronic record. What does it say? Where any law provides that document records information shall be retained for any specific period, then the requirement shall be deemed to be satisfied if the documents, records and information is retained in electronic form. Means if any law prescribes that this books must be maintained for 6 years or 5 years also, it is deemed to be complied when we are maintaining books of accounts in electronic form also. That's why we have changed the Indian Evidence Act or Indian Penal Code, so that you can keep this documents in electronic form and validity remains. So what is that? What we have to take care for retention of electronic records? While maintaining the retention of electronic records, you must see that the information contained in these remains accessible to so as it can be used for subsequent reference. Means when you are storing the electronic record, you must also see that information present in it is accessible for subsequent reference. The electronic record is written in the format in which it was originally generated, sent or received, or in a format which can be demonstrated to represent accurately the information originally generated, sent or received. Means the electronic record is written in the way in the form in which you have got, you are saving in that form only, or it is kept in such a format which can demonstrate that the information which has been received is presented accurately. Means either you keep that in a one mode in which it has been received, or you change the format, but the format must accurately show that the information originally generated has been preserved and is intact. Then the details which will facilitate identification of the origin, destination, date and time of dispatch or receipt of the electronic record as available in the electronic record. So the details of origin, dispatch, from where it is originating to where it was dispatched, when it was received, etc. must be available for the electronic record. Provided that this clause does not apply to information which automatically generated solely for the purpose of enabling electronic record to be dispatched or received. Means if there are any automatic emails or automatic generated emails, this won't come under that. So retention of electronic record, how can you say that? First thing, it is information contained in it is accessible for subsequent reference. The electronic record is written in a format in which it is also generated, sent or received, or in a format, or it can be kept in a format which shows demonstrates accurately the information originally generated, sent or received. The details which will facilitate identification of the origin, destination, date and time of dispatch or receipt of such electronic record as are available in the electronic record. So these are the three important things which we must keep in mind when we are trying to retain the electronic record. Now let us see what is the power of central government in respect of electronic signature. So we are authenticating the document using electronic signature. So what is the power of central government in terms of electronic signature? So section 10 says about powers to make the rules by central government in respect of electronic signature. What are the powers? The central government, for the purpose of this thing, as usual, it can place the rules, and what does it prescribe? It will say the type of electronic signature, or the manner and format in which it should be affixed, the manner and procedure which will facilitate the identification of the person fixing it, the control process and procedure to ensure adequacy, integrity, security and confidentiality of the electronic records, because these three, confidentiality, integrity, availability, are one of the most important process for the authentication of data. Then any other matter which is necessary to give legal effect to electronic signature. So what the powers of what are the different kind of rules can be made by central government? What is the type of electronic signature? What is the manner and format in which it has to be affixed? What is the manner or procedure to identify the person who is affixing it? Then what is the control process and procedure to ensure adequate integrity, security and confidentiality of electronic data? Then any other matters which are necessary to give legal effect to the electronic signature. So this is the power of central government under section 10 to make rules in respect of electronic signature. So in the coming video we will be seeing what are the requirements of authorities like IRDA, RBI and SEBI regarding the regarding system control and audit, and we're also going to see the SEBI audit norms, and we'll try to even complete cyber forensic and cyber fraud investigation. So till then, once I request you to go through this PDF and complete the practice manual, and let's meet in next video.